This is Daryl Tuttle, and this is another Living Care Learning tutorial on advanced directive, sometimes called a living will. And a living will is a paper. It's a document, but it's an important document because it allows you to document your final wishes concerning medical treatment at the end of your life. And candidly, what's more important than that? You would think that the process of dying would not require paperwork, and I personally wish that it didn't, but we live in a complicated era, and the medical profession has requirements, rightly so. And so I want you to imagine, if you're going through this now, you don't need to imagine it, but if you're healthy, just kind of close your eyes and think about some of the worst case scenarios. One would be the famous, I hate using this expression, but I'm just going to put it out there just because that's what my clients say to me. And that is vegetative state. And so a person who's has suffered a brain injury, or, there's like a million reasons you could be in a quote unquote vegetative state, but that's what people fear. But it also could be you or a loved one suffering from a terminal illness that there is no realistic hope of surviving, and cancer comes to mind. And the illness is so bad that you are too ill to feel better or even well. And then also imagine, most folks who are going through that process may not even necessarily be aware of it. They've reached a point where they're either permanently unconscious in a hospital bed somewhere, skilled nursing community, or imagine also just a person who's heavily medicated, pain medication, so you're not suffering. However, it's stressful for the family. The family members and loved ones who watch it, sometimes there's dispute and unneeded and unnecessary stress about how to handle those last weeks or months or days because it wasn't written down. And so one of the teaching points of this tutorial is use the living will, the advanced directive, the document that we're talking about, to also communicate with your family about what your desires are in the final time. And so this is a provision from a living will. Remember, a living will is a directive to a physician ordering them how to treat your final days. And the number one thing people utmost importance is, if you are diagnosed to be in a terminal condition or in a permanent unconscious state, which of those do you want? Do you want to be kept artificially alive as long as the machines work, or do you not want to be kept alive? And choosing the right selection can have a big impact on you and your family. I can tell you that, if you can see my cursor here, 99.9% of my clients do not want to be kept artificially alive indefinitely. And they, these are my clients' words. Maybe you would view it differently, but they kind of laugh and they call it the pull the plug paragraph. Do you want the plug pulled or not? So, a little unsophisticated, but it gets the point across. And then next is, you need to know that before your living will can guide medical decision making, two physicians must certify. But you're unable to make medical decisions. So, this isn't, you go in with your power of attorney with the sniffles and they're time to pull the plug. It has to be certified by two medical professions in most states. And the physician, remember, this is, the living will is state specific. We'll talk about that. And according to a state law. So in order to meet your state's statute, the living will law in your state, a physician, it's usually certifying that you're terminally ill or permanently unconscious, or both. And then we need to also understand that the power of attorney, there's like two sets of documents that are necessary. The first is, you have a directive. You have, while you had mental capacity, you signed the living will, indicated that you did not want to be kept alive indefinitely, and you also appointed in a separate document a person to make decisions for you. That's called a power of attorney. There are two separate documents. You need both, power of attorney and advance directive. And we have a separate tutorial on medical powers of attorney that you should watch if you haven't already. But the power of this is a provision. This is just one of the paragraphs from the documents that we draft. So the power of attorney accompanies the living will. My attorney, in fact, I'm reading it. My attorney, in fact, shall have the powers necessary to make decisions about my health care. These powers of attorney shall include, but not limited to, the power to obtain medical blah, blah, blah. So the point is, you are, in the living will, directing how you want to be treated in that permanently unconscious, vegetative, terminally ill state. And in a separate document, you've given the authority to someone else to make those decisions for you, because you can't do it. You're unconscious. Now, before a medical power of attorney goes into effect, remember that the person's physician must conclude that they are unable to make decisions for themselves. And then the next thing is advance directives are legally valid throughout the United States. You don't need a lawyer to do an advance directive. I mean, technically, you don't need a lawyer to do a last will and testament. If you draft your own last will and testament according to the requirements of your state, it's not invalid just because you didn't hire a lawyer and paid a bunch of money. However, the advantage to working with an attorney is they theoretically know the laws, and the requirements are in your document. And remember, there's 50 different states, so 50 different variations. And, don't get confused. Let me distinguish also, another important thing to remember is that there is a separate document called a POST, and that stands for Physician Order on Life-Sustaining Treatment. And, you're probably not going to the grocery store and taking your living will and your last will and testament and your power of attorney with you. Just in case I have a heart attack while shopping, I better bring this with me. And even if you did, ambulance drivers and emergency medical technicians do not honor living wills. They have a duty to show up on the scene of the accident and get you to the hospital and keep you alive. It's at the hospital where, intensive care or, all these other scenarios that you can imagine that the advance directive comes into play. And a pulse is just, if my heart stops beating, do I want the physicians and nurses and whatnot to restart my heart? So, I guess technically you should have a pulse, a living will, and a power of attorney. And here I just thought I would spend the last part of the video just talking about other provisions that we will include for you, some examples. You can absolutely indicate how you want your organs handled after. If you want to donate or organ tissue, you can and should put that into your advance directive. You can also appoint a guardian. So suppose you signed and created your advance directive when you were still young, even 40 years old. And if someone needed to act as a guardian because powers of attorney were not available or willing to act, then you can nominate the person that you want to act as your guardian. And then my final word of advice is customize it. Remember, this is your life. It's the end of life. It's how you anticipate dying. And if you have religious considerations or something that you want to communicate, that is the time to say it. Write it down ahead of time, because most people will not read this until they get that horrible phone call and they learn that you're terminally ill or you've been in an accident and you're permanently unconscious. And if it's not written down, God bless you, because no one's going to be able to read your mind at that time. And so it's easy to start. If you're watching this video from some other source, you can go to livingcarelearning.com, and if you're already there, you can start now. Just hit the button and creating your own advance directive at Living Well is easy, it's affordable, and painless. And we'll just get that form sent right out to you.